Thank you all for joining us this evening. My name is Sandra Slifer, and I'm the president of the League of Women Voters of Louisiana, and I'm pleased to be here on behalf of the League of Women Voters of St. Tammany for this candidate forum between the Division L candidates running for the 22nd Judicial District. This is a juvenile and family court seat, and just to let people know that Division L is not a geographic boundary. I always have voters contact me every election asking me if they live in Division L or Division K, and that those are not geographic boundaries, that all voters who live in St. Tammany and Washington parishes are going to be voting for this seat. So just to get a little housekeeping out of the way, that I'd first like to thank Trey Foles, the superintendent of St. Tammany Parish Schools, for allowing us to use this beautiful facility and for taping the forums this evening. That St. Tammany Parish Government will be showing them on Access St. Tammany as well as on the parish government website. So there's government working together, which is always a good thing. That we're here tonight with two of the candidates that are running for the Division L seat, Judge Dawn Amacker and Attorney Nanine McCool. That I'm going to encourage the audience to write down their questions on the 3x5 cards that are being passed out, and then just hold your card up and someone will come by and pick it up, and our screeners are doing their best to manage all of the questions that we're receiving. So please do that. We're going to start first with our opening statements from the candidates. Each of our candidates will have 2 minutes for their opening statement, and we'll begin with you, Ms. Amacker.
I've got to get my mic on here. Can you hear me in the back? It's good. I am Judge Dawn Amacker. I'm one of the two judges of family court. When I came 6 years ago here and talked with you at the League of Women Voters, we were establishing our court. So I was selling the court, and I was also running to be one of the first two judges. I'm now into almost 6 years. We're very proud of the court. Have quite a few of the court personnel here with me today. We have a state-of-the-art family court that is the envy of all the jurisdictions in the state. We have quite a few people that come and visit us. My husband's here tonight of almost 30 years, Ted. There he is in the front. We have one beautiful daughter who's the light of our life, Sasha, and she's 27 and brought us a son-in-law this year into the family. And we love them very much. I am proud to say I got both the Alliance endorsement in this race, had it last time, had it this time, and RPEC of St. Tammany, the Republican Party, has also endorsed me as well. I do seek the support of the League of Women Voters individually and everyone here. No one could work any harder. No one could love your children and the families more. Our work ethic is unparalleled there in the division. We put record hours on the bench there, and we take matters very seriously, do our homework, and make sure that all the cases are well prepared before we hear things. We have many innovations in family court. We call it a therapeutic family court rather than a litigation model. And we have hearing officers that get quick orders in, and we make many things a priority, but in particular, making sure that no child is harmed, no person is harmed. They are always protected in our court, and we have zero tolerance for non-support as well. So we welcome you to come visit us if you're ever up there on the 3rd floor. Thank you very much.
Thank you, Ms. Amacker. That our timekeeper is Jamie Huard. You're going to see her over here. She's going to be holding up cards. When you see the yellow card, you will have 30 seconds remaining, and the red card does mean stop. So, yeah, please be mindful of our timekeeper. Ms. McCool, you'll have 2 minutes for your opening statement.
Thank you, and it is a pleasure to be here. My name is Nanine McCool. I am running for the Division L seat. I have been practicing law for 14 years. I became an attorney specifically because I wanted to practice family law, And in particular, I was concerned about protecting victims of domestic violence and children from abuse. Two areas of family law which are have very specific and distinct characteristics that require a very specific approach. My background is pretty straightforward. I grew up in New Orleans. My father was a school teacher. I joined the Coast Guard when I was 18 and served 4.5 years on active duty because my parents couldn't afford to put me through college, and I didn't expect them to. The Coast Guard gave me a means to be able to afford college. I was activated for Desert Storm because I was in the Ready Reserve. I was the first female coxswain and boat captain in Coast Guard Group Galveston Station and ran search and rescue there. I was the first female port security coxswain, the raider boat coxswain for Port Security Unit 3. I went to law school because I wanted to be an advocate for children. I was excited about the family court that was created here in 2009 when Judge Amacker and Judge Devereaux first took the bench. And I am running now because I strongly believe that we have gone in the wrong direction and we need a change of course. And I am hoping that you will support me in this election for an important change that we need in family court. Thank you.
Thank you, Ms. McCool. Well, we have a lot of questions here for both of you, and that helping us this evening are some students from Mandeville High School Youth in Government, and that we're thrilled to have these young people here with us this evening, and they really are the hope of our future. So, before you leave this evening, make sure you thank them for coming out, and they've got a long row ahead of them. We're going to start with a question that is for both judges.
One judge, one candidate.
For both candidates. Thank you. What we'll do is that we've allotted some time for you to have 2 minutes to answer a question of your choice, and that most of the time the answers will be limited to 1 minute. Please let us know if you are going to take 2 minutes for any of the questions that we are going to be asking, and our timekeeper will make that adjustment. This is a question for both candidates. In addition to campaign financial reports, Rule XL 40 of the rules of the Louisiana Supreme Court requires candidates for judicial office to file a personal financial disclosure statement within 10 days of filing his or her notice of candidacy. Have you filed this disclosure? And we'll start with Ms. McCool.
Yeah, no, mine's delinquent, and it's actually my car to be notarized and sent in.
Okay, thank you. Ms. Amacker?
Oh, yes, mine was filed months ago. Mine's been of record, yes.
All right, that was short. Thank you. That we'll stick with both questions, or both candidates here. And we'll start with Ms. Amacker. What are your thoughts on transparency and accountability, and how will you implement them in your court?
Well, we have full transparency. We have an open court, of course. All of this is state law. Family court involves quite a few things, though, that there are closed courtrooms and there are sealed proceedings. Unlike other things that are done at the courthouse, the protection of children and the best interest of children are the most important things. So, by law, all the juvenile proceedings are closed, sealed proceedings, and that is a huge part of family court. Also, the adoption proceedings are all sealed. When children are interviewed in chambers, and we have Watermeyer hearings and other things that occur with very sensitive testimony at times in the discretion of the court, things are sealed. Out of probably 8,000 cases that have been assigned to me through the past few years, less than half a dozen have been sealed by me as the judge. Most all of these are sealed by operation of law or by request of the parties. Quite often the parents will request it because, of course, these things are online. And these days young people know how to go online and look and see what their parents have said in all of their terrible divorce cases. And we have many of the family court lawyers that are out here today, and they can certainly explain to any of you why you would not want that to happen. Parents have been known to post things on social media, discuss things. Children have read things about the medical history and other things concerning their parents that have disturbed them greatly. And this is what we want to do, is to protect them as well.
Thank you, Ms. Amacker. Was that a 2-minute answer?
That was less than 2, almost 2.
Okay. Yeah, that we will want you to, make sure that that was not, that let's stick to 1 minute when it's a 1-minute answer, please.
It's supposed to be 2 minutes.
No, I'm sorry. Again, if you are looking for, if you would like for your answer to extend to 2 minutes, please let me know, and we'll make sure that the time does adjust, is adjusted
You
accordingly.
just need to adjust the time she's showing us, because I did not know that. As she's showing us, it still showed I had time
All
left.
right,
Sorry, Sandra.
that the candidates are going to let us know, that, so, Ms. McCool, you will have a longer amount of time, that I believe perhaps it was 1.5 minutes, that Ms. Amacker was given for this answer. And I'll be glad to repeat the question if you'd like.
No, I remember it. So I believe that transparency is essential to accountability, and I think accountability is essential, particularly in the judiciary, if we want to maintain an independent and honorable judiciary. The rule of law is the fundamental principle upon which this country is based. It is the source of all justice. So without transparency, which requires that things be done on the record, not in chambers behind closed doors. I think parties should be allowed upon request to obtain the audio recordings from their proceedings. I don't believe in sealing entire records. I believe our Constitution does not allow for the sealing of entire records unless it is by operation of law, such as in a juvenile proceeding, but that rarely applies in a family court case. I also believe that in order to encourage transparency, complaints against judges should be put online so that people can know how many complaints have been filed and what the nature of those complaints are. And I waive all confidentiality related to any complaint that has been ever filed against me. I believe we need a court watch so that the public can stay engaged in the family court and know what's going on. Fundamentally, I think transparency and accountability are essential to the system, and we don't currently have enough of it.
Thank you, Ms. McCool. We'll have time for more questions if you want to hold your applause till the end. That it's up to you. This is a question for Ms. McCool. In regards to your Facebook post, the complaint, people think that something is wrong. Can you state your position? In regard to your Facebook post, complaint, people think something is wrong. Can you state your position?
So my understanding of this question is that Judge Amacker filed a complaint against me regarding a Facebook post. She filed that complaint, I think, with all 3 agencies, the ODC, the Office of Special Counsel, and the Campaign Commission. And, the short answer to that is that I believe that I have a First Amendment right to say whatever I want on my Facebook page, and that Judge Amacker has an obligation, according to the judicial canon, specifically Canon 3A6, to protect herself from ex parte communications. So if she exposed herself to that because she actively went to my Facebook page and had someone report back to her, that's not my responsibility. That responsibility lies with her.
Okay. Thank you, Ms. McCool. Ms. Amacker, have you ever had any complaint filed against you as a judge?
Yes, and as you know, Sandra, those are confidential. Every family court judge and every family court practitioner probably sitting in here has had complaints filed. I have never, in 32 years, had any, there was never any merit to any of them, any finding of any disciplinary action whatsoever. I have a blemish-free record as a lawyer and as a judge.
Thank you, Ms. Amacker. That I'll stay with Ms. Amacker, and that a lot of these questions are directed at just one candidate or the other, so we're going to go back and forth some here. Ms. Amacker, how many moms have you ordered to jail, and what were the primary reasons?
Well, Ms. Slifer, I think I've had 50,000, maybe, well, between 40 and 50,000 probably matters, rules, motions, proceedings in front of me. As far as how many mothers have gone to jail, how many women have gone to jail, one, maybe two.
Thank you, Ms. Amacker. Ms. McCool, do you believe that you have maintained the dignity appropriate to judicial office in your campaign?
Yes.
Okay. All right. And I'll stay with Ms. McCool for this next question. What is your motivation for running for judge at this time?
As I said, I became an attorney specifically for the purpose of practicing family law, and I was particularly interested in protecting victims of domestic violence and ensuring that children who were victims of sexual abuse were also protected. When I became an attorney, obviously I was a little bit naive. I became an attorney, and I did grow to understand that this is a very difficult and complex issue. When we had when the family court was created here in 2009, I was excited about that prospect. I am now no longer excited about that prospect. I am deeply concerned about the direction that we are going in, and that I believe if we do not change direction, we do not do so at our own peril and at the peril of our families and our children.
Thank you, Ms. McCool. Ms. Amacker, in court documents, you have commented that clocked documents are modified all of the time in your court. Please explain this process and what safeguards are in place to protect the public record.
Ms. Slifer, someone told me that that comment was made by someone on a site. I have no earthly idea what they're talking about, and there would have to be some foundation laid for me to believe that I ever said anything like that. I've never altered any record. I would never do that. The only thing that has been done that I could possibly think of that they're picking up from a record, there are times on certain orders and other things in open court with the attorneys there that they amend or decide to amend an order rather than them have to pay the court cost for us to go in and get something refiled. We will, with full transparency and agreement of everyone, say, do you want me just to write this in on your order? Then the clerk's office can then rescan it and put it in the record. But the idea that I've ever altered any clocked-in documents is absolutely ridiculous. It has never happened.
Thank you, Ms. Amacker. That this is for both candidates. And I will start with Ms. McCool. Do you think a parent that has been convicted of domestic violence should be given sole custody?
The statute expressly prohibits someone who has been shown to be a perpetrator of domestic violence from having custody. And that is one of the reasons why I became an attorney and why I now believe that it is imperative that we change direction. Domestic violence is a persistent problem. It presents a significant danger to our society, and the courts, in my experience, and particularly in Division L, lack any understanding of how this dynamic affects, and I want to take 2 minutes on this question, how this dynamic presents in front of attorneys and how it is treated within the courts. It is my experience that women, and I want to clarify that women are not always the victims of domestic violence. It's sometimes that it is a man that's a victim, but those instances are rare because of the very nature of how domestic violence presents. However, when the courts fail to recognize what domestic violence looks like, when they punish parents for making the allegation of violence or sexual abuse, and in deciding that the evidence that was brought was not sufficient to prove the case, rather than saying you didn't prove your case and leaving it at that, the current practice is to punish the parent that brings the allegation by calling them a liar, saying that they brainwashed their children, which if anyone who knows anything about domestic violence and children knows that it's very, very difficult to do, that false allegations, contrary to popular opinion, are very, very rare, then we have a problem in our family courts. And I hope that my fellow attorneys out there are listening, because if you care about families and you care about this area of law, then you need to realize that we are failing in that area, and people are dying because of it. So we need to address it, and we need to address it not only in the courts, but within the profession and within the community. And I have to stop.
Thank you, Ms. McCool. Ms. Amacker, you'll have the same question. I'll be glad to repeat any questions that you'd like.
Would you repeat that one for
I
me,
sure will.
Sandra?
Do you think a parent that has been convicted of domestic violence should be given sole custody?
Well, what I do is rule according to the law. We do have the Post-Separation Family Violence Act that's been in effect for some time. We take that very seriously. There are things that a parent has to do to even get to visit their child without supervision under the Post-Separation Family Violence Act if they have been convicted of a very serious act or many acts of violence. All of the attorneys that are sitting in here and all the other more than 200 attorneys that have endorsed me in family court, including all of the specialists in the entire district that can endorse, they will tell you that this has been a priority. We've always made it a priority. The entire time that I've been a judge, I know of no child or no one that's been injured because of any ruling that I've made. And that's hard to say because everyone makes mistakes and things happen. I was the first judge that actually has people come in if they want to dismiss a protective order. And I'll take my 2 minutes on this one. Thank you, ma'am. I was the first one that make them come in because the threat and the intimidation is so present with women to dismiss the protective orders. The husbands will want them back. The boyfriends will promise them anything. That I make them come in front of me, and that perpetrator is going to be asked very serious questions before I dismiss the protective order. And in many cases, I do not dismiss the protective order. I allow them to reconcile if they want to, but I'll leave that protective order in place. The priority with our court is the protection of children and the protection of vulnerable parties, mostly women. Now and then, we have had a woman who is a perpetrator. And the idea that our court, Judge Devereaux and my court, do not protect women and children is not true, never has been true, and if it was a problem, all of these attorneys and everyone that's endorsed me would not be endorsing me. I can assure you that. Thank you.
Thank you, Ms. Amacker. That I will stay with Ms. Amacker. When you receive letters defending the character of the people, the parties, do you read the letters from both parties that are submitted?
We cannot, Sandra. We can't read the letter from either party. We have many people who send, we call those ex parte communications into the court. We can't read any of those. We have, in fact, my administrative assistant is sitting right back there, Ms. Michelle Simon, and she is trained very well to very politely send those things back to the parties. They never, ever get to me, and that is for good reason. Judges have to be independent. They can't be influenced by outside influences, and everyone should have the same opportunity in court to prove their case to the judge. But no, we never see any of those.
Okay. Thank you, Ms. Amacker. This is for Ms. McCool. Does your law firm and your husband owe outstanding liens?
No.
Thank you.
I'm not sure I understand the question. I mean, I have a lien on my personal property at home, nothing on my law practice, and obviously I have a mortgage on my home and we have rental property, but
Okay.
those kind of mortgages.
Thank you. All right, that since that was kind of a short question, I'm going to go to a question that is for, no, well, I don't know. All right, well, we'll stay on this. Yeah, apparently someone feels very strongly about this. I don't, that, because they typed this up, no less. That, and this is for both candidates. And so we'll stay with you, Ms. McCool, on this, and we'll see if there's anything. And then we'll go to Ms. Amacker on the same question. Are you in default of payment of any loans or other debts? Have you been sued for non-payment of any debts?
My student loans, I had to allow to default in order to restructure them, but they are currently up to date. I'm not aware of being behind on any other debts, but I have to tell you, I do a lot of pro bono work. My husband, I'm incredibly lucky that my husband has never expected me to make money in my law practice, and I have never made money in my law practice. It is essentially run as a nonprofit organization, and so we live very simply and occasionally have gotten behind. When my husband lost his job a few years ago, we really struggled, but right now I think we're up to date on everything. He does manage the bills, though, because all I do is law.
Thank you. Ms. McCool, Ms. Amacker?
No, my husband and I pay our debts, we pay our taxes, we don't have any tax liens, never have, never been sued on a debt, never defaulted on a student loan, and very financially stable.
Okay. All right. That I'll stay with you, Ms. Amacker. I've got a couple of questions here pertaining to your time on the bench in terms of attendance and personal days. That, is this a topic, or, is there, do you feel as if this is, that the personal days or your attendance on the bench has been exemplary or has been average?
I'm so glad you asked that question.
Yeah, I've got a couple of questions about it. So
I have spent
anyway.
record hours on the bench, Ms. Slifer. I'm sure more than any other judge doing family court has ever done in the history of the 22nd JDC. I'm always in the top 1 or 2 of total hours on the bench that are informally kept, the hours from the clerk's office. I work nights doing my homework for court. I've got court tomorrow. I'll work on that tonight. I work holidays. I take very little time off, not nearly as much time as I should. My vacations are usually very short, and the work comes first. The worst part of a campaign is a bit of a distraction from the work. But no one works harder than I am. And any of these attorneys and anyone you ask at that courthouse, they know who's in the parking lot, and I'm there as much or more than anyone ever has been in the 22nd JDC.
Okay. Thank you, Ms. Amacker.
Thank you.
That, Ms. McCool, this is for you. Are there any outstanding issues regarding your professional conduct?
There is a complaint. Judge Amacker and Judge Gambrell initiated this complaint against me, and it was filed in 2011. It was outstanding for 2 years. Judge Amacker pushed information to the ODC without my knowledge. That resulted in formal charges a week after I announced that I would run against Judge Amacker. And there was a hearing in February and March of this year. And then the ODC made recommendations that I be suspended from the practice of law for 1 year and a day. It is currently before the Louisiana Attorney Disciplinary Board, waiting for their findings after oral argument on September 4th, and then ultimately will be decided by the Supreme Court. And there have been several more complaints filed against me by Judge Amacker since the qualifying period closed.
Thank you, Ms. McCool. That this is for Judge Amacker. Have you ever denied and dismissed an application for TRO and protective order without allowing a hearing?
Can you repeat that question, Ms. Slifer? I'm not so sure I understand it.
Sure. That have you ever denied and dismissed an application for TRO and protective order without allowing a hearing?
Yes, I'm sure I have. we get hundreds of protective orders that come through. They have to meet basic requirements of the statute. If they do not, then many times all of the judges, including me, have had to dismiss, or at times, if there's any question about it, if it even begins to make a case, then it is set for hearing in front of the commissioner. It's rare. Most of the protective orders are set for hearing in front of the commissioner, but some of them have that do not state any case whatsoever, that there's been any type of violence or threat of violence that would rise to the level of protective order. Those do have to be denied, yes.
Okay. All right. Thank you. That I've got more questions for Judge Amacker that I don't think we're going to be able to get to all of them and still, maintain some sense of time here, but we did get started late. That this was in the news, so I will ask this question of Judge Amacker. Why do you fax recusal orders to your husband's firm and other attorney firms from your office?
Well, there's been one order that is at issue that was faxed to my husband's law office. This was not faxed to any attorney in connection with any other case except my recusal case. I do have a private attorney. They have a large law firm who for some time had represented me personally in connection with recusal actions. On that particular date in question, I was not called as a witness. The attorney was not there to appear, and I am allowed to have a private attorney to give me advice on these matters, and I faxed, or had faxed from my office, a copy simply of the order that Judge Burris had faxed to my office, to my private attorney, granting the recusal action for my file and for general discussion about the recusal in general, which I'm allowed to do.
Great. Thank you. I'm going to ask one more question from both candidates, and then we're going to do the closing statements. That I do have a lot of other questions that have been addressed to you, Ms. Amacker, that it may be, some people will want to see you afterwards, perhaps in the anteroom here, that to get some of the other questions answered. But in the interest of time with our other candidates, that I will ask one more question from both of you, and I'll start with Ms. McCool. I'm sorry, that this has to do with accepting political campaign contributions. And I'm going to read both questions. I think they're similar enough to combine them into one answer, though. The first question was, do you think it is ethical for a judge to accept significant fundraisers and contributions from an attorney in a custody case that is hostile? Then the second question was, do you think a judge should accept significant political contributions? Oh, very similar. From an attorney while presiding over a hostile custody case against that attorney. And so I'll start with you, Ms. McCool.
I think there is a general consensus among the public that this is inappropriate. But I have to say on this issue, the way the system works, it almost requires that judges accept donations from other attorneys. The public rarely gets involved in judicial elections. Elections cost money. When the only people who are willing to contribute to the election are other attorneys who practice in front of that judge, you do have that appearance of impropriety, but I don't necessarily believe that it is improper. That ultimately depends on the character and the integrity of the person on the bench. I do think we have problems with our campaign finance rules, particularly when it comes to judges, but based on the way that question is posed, I can't say that it's necessarily unethical. That would depend on the conduct of the particular judge and the particular attorney who's made that contribution.
Thank you, Ms. McCool. Ms. Amacker.
Well, I agree with her on that point. It certainly is ethical in the state of Louisiana. It's the way the state works is that you have to raise funds, obviously, to run for office. Probably everyone would prefer not to do that, quite frankly, but there are no private funds, and we can't expect the citizens to pay for people to get their message out. which you have to do these days. And, you have to get your message out in order to run. And we have a huge district. It's a major office, so you can imagine the expense. I have a committee that takes care of that. I don't solicit funds personally. I can't do that. Neither candidate can. We both have asked for contributions through our committees from the bar. And I enjoy great support from many citizens and the bar, of which I am very grateful. But that is run by your committee, and you can't accept them personally, and you can't solicit on your own. But yes, it would be preferable not to have to do that, but that's the system that we have right now.
Okay. Thank you, Ms. Amacker. As I said, we have a lot of other questions that we're not going to have time to get to, but I do want to thank each of the candidates. We're going to now give each of the candidates 1.5 minutes to make a closing statement. And we'll start with you, Ms. McCool.
Thank you, Sandra. I want to reach out to particularly the members of the bar who are in the family bar here. I want to invite each and every one of you to reach out to me and ask me any questions, address any of your concerns to me, because I am completely transparent. And I know that there's been a lot of rumors that I am doing something to be vindictive, or whatever my motives are for running in this race. And I would just appreciate the opportunity as my peers to respond to those concerns. My motivation for running in this race is not to do anything except improve the bar and improve your ability to practice law and to do what I think all of us became attorneys to do, which is to represent our clients and to do good. And to the rest of you, I do want to say that this is an incredibly difficult job. I do not want to suggest in any way, shape, or form that this is an easy thing or that I take it on lightly. I would not be running if I did not believe that I could do a very good job and that I could do a better job in the sense that I would go in an entirely different direction than we currently go, and we are currently going. And that, first and foremost, would be that we are going to be bound by the rule of law. It will not be my discretion. I will not treat your children like my children. I will treat your children like your children. I will concede that you know your children better than I do and that you have a right to parent your children. So I just want to encourage everyone out there, if they have a question of me or they have a concern about me, please ask me, and I will answer as transparently as possible. Thank you very much, and I hope you'll vote for me on November 4th, 2014.
Thank you. Thank you, Ms. McCool. Ms. Amacker, you'll now have 1.5 minutes for your closing statement.
Well, thank you very much. It's been an honor being your judge for 6 years. I've worked very hard. My family is the most important thing to me, and then that court is the next most important thing. This has been my career, my life. 32 years I've done this. It's all really I've ever done in my career. I've been involved in every major innovation there's ever been in this state, and had it not been for Judge Devereaux and I, we wouldn't have this family court right here. We have a similar vision. It runs beautifully. The idea it needs to be changed, it doesn't need to be changed. This is a well-run court. People are taken care of. We have made innovations, including mediation and work on a collaborative level with so many community-based providers and services, and every day is devoted to your children and your families. And the idea that that needs to be changed and us start over and do something different that works so well and is a state-of-the-art family court, that's not needed. We need to continue the hard work. We have many plans for the next term. This has been the building and the structure term. The next one will be the vision term, when we can really begin to do things that we've really imagined but haven't been able to do. We've had Court Improvement Week for almost 6 years now, and it's unfortunate that Ms. McCool, with all of her ideas, has not been able to come in and visit with everyone else and put those forth. She's had an opportunity to do that, but we would invite her in the future. Thank you.
Thank you, Ms. Thank you, Ms. Amacker. That, just as a reminder, that we do have the online voter guide, that candidates' answers will be posted shortly after that October 1st deadline. So we do encourage voters to go to the league's website, lwvofst.org, to get more information. Thank you both for coming.